They have like some things.
Hello, everybody. So we have a bunch of people joining us virtually. So you have a lot of compatriots who are online right now. Just making sure that everybody can hear okay with masks and everything. All right, excellent. Thank you, Beth. I can always count on you. Welcome, everybody. This is Constitution Day 2021. We are very happy to see all of you and have you all in the meet as well. And we have what we think is going to be a really interesting discussion today. And I know some awesome people are up here, so I have no doubts that you're going to have a great discussion. Before we get started, I'll turn it over to the moderator here in a second. I just want to say that this is sponsored and organized by the General Education Program. This is the first year that we decided to take over the Constitution Day organization, mainly because we felt like it really did fit in with the outcomes and the goals of the General Education Program, specifically the civic learning one. But with the panel that we're doing today, we also are going to have some interesting discussions about ethical reasoning as well. So we really are excited to this be our first one. We're hoping next year we can do even more, whenever hopefully all of the restrictions are a little bit lessened at least. But this year we have an awesome panel. So what we're going to do is I'm going to turn this over to Dr. Paul Weizer from the Economics, Political Science, and History Department. I said that completely out of order. Economics, History, Political Science Department. And then he's going to be our moderator for today. So have a great time.
And thank you, Dr. Tracy. Appreciate that. And thank you, everybody, for coming this afternoon to our Constitution Day panel. Again, my name is Paul Weizer. It's my pleasure to welcome you to our commemoration of Constitution Day 2021. For anybody who doesn't know what that means, very simply, today is the anniversary of the ratification of the Constitution. So a long time ago, the Founding Fathers got together in Philadelphia and they signed this document. And that's the document that's guided our federal government ever since. About 10 or so years ago, the federal government got together and decided that every school in the United States who receives federal financial aid, which is basically every school in the United States, is required by law to do some commemoration of this observation. And I'm proud of some of the great things that we've done at Fitchburg State, and I think you're going to find that today's panel is a particularly relevant and interesting one as well. So let me introduce the panel and tell you a little bit what they'll be speaking about, and then we'll go accordingly. I have just two slides for you. The one I have up there, I think, is the thematic approach to the last year, and that's a lot of what we deal with, and I will give you the second one at the very end. So the first two speakers are going to be our Moot Court team captains this year, Miranda, Gustin, and Bill. This year's Moot Court problem that's being argued all across the United States and Canada deals with a hypothetical legal challenge to a mandatory vaccine law. And when Dr. Tracy approached us and said, hey, we'd like to do a panel looking at the constitutional and legal implications of vaccines and requirements, I said, I have a couple of people in mind who might be really good at that. And so they were good enough to come along and work with me today. While it's still early in the semester, Miranda and Ben have completed our 1,000+ pages of reading for the semester and are far enough along in their studies to speak to you a little bit today about the leading constitutional precedents about the different legal avenues the challengers might make under such a circumstance. First up, Miranda's going to discuss the power of Congress to require a vaccine as part of its authority under the Interstate Commerce Clause, and then Ben will discuss the argument against a vaccine mandate by looking at the concept of substantive due process and the right to privacy. Our second speaker, Dr. Zachary, he's going to address the debates over what types of stores were deemed essential businesses during the COVID-19 pandemic, and specifically focusing on arguments made by gun stores that they should be considered essential. It's an interesting question. The Supreme Court heard a legal challenge from churches on this topic in 2020. And they did find that churches could remain open despite public health challenges because of the First Amendment rights involved. But the Second Amendment is a much murkier issue, and where that falls is a very open legal question, and Dr. Weizer will speak to us about that today. He will discuss the arguments made by both proponents and opponents of the position, more broadly what type of restrictions on firearms ownership and sales have been considered constitutional or unconstitutional in the past. And then finally, wrapping that up, will be Dr. David Svolba. He'll move us from the legal to the existential realm by asking the question, do we have a legal, not a legal, an ethical obligation to get vaccinated? And after framing the need to interpret the ethical question differently from a legal or constitutional question, he'll discuss the main arguments for and against the view that people who refuse to get vaccinated are acting unethically or blameworthy for their conduct. So a lot of different perspectives on this issue, all of which tie directly into our theme in celebrating the Constitution. So without further delay, let me bring up Miranda and Gustin, who will start us off.
That's a question I have to ask, but we're working with it. All right, so my name's Miranda. I'm a junior political science major, and this is my second year in Moot Court. This case is currently like the most relevant case that I think we've had in a long time. Last year we dealt with First Amendment issues, but this one we're dealing with something that we are currently questioning ourselves today. And it's whether or not the government can legally mandate a vaccination. Our first issue that we're discussing in class is the Commerce Clause. The Commerce Clause in a first modern use was used in 1942 in Wicker v. Fitchburg. The Commerce Clause was defined in that case that any issue that has an effect on commerce is an issue that the government can restrict, regulate, apply any sort of restrictions to it in order to ensue a continuous flow of our economy. The government, using that definition, was able to constitutionally use it in a number of different cases, such as segregation in motels. They used it as a way to, in a case specifically, it's called the Heart of Atlanta of the United States. This case specifically used the Commerce Clause as a way to argue against segregation in motels. This motel specifically advertised as a national landmark. They wanted to bring people in from all states into their hotel. Sorry, I'm a little nervous. But they wanted to bring it into their hotel, and in order to stop segregation in 1964, I believe, 1964, they used the Commerce Clause as a way to be like, well, you have to include all people. You have to, as much as it's your right to invite anyone you want in, you are advertising as an international or interstate commercial business. Therefore, you are under our jurisdiction. You have to accept who we want you to accept, not just who we want to accept. And then they also use it as a way to, if you are excluding people from renting a hotel room, and if you're excluding people from inviting them in, then that will in turn affect your commercial activity too, which would inhibit the economy. And then this went on from 1942 to 1995. They won every case up until then, where the United States v. Lopez in 1995 challenged this idea of the Commerce Clause and the definitions that they have it. And this one is actually a definition that we have today. The United States v. Lopez dealt with gun issues, whether or not handling a gun is a commerce issue versus buying it. So we're not talking about buying it, we're talking about having a gun. This issue was discussed, like whether or not it was a commercial issue if you were to have one in schools. The government argued that because students were in the area where there was a gun involved, it would affect their learning ability, it would affect their ability to go to college, which in turn would affect them to have a job, and then which continue to go. So it would be a spiral effect. However, this issue was shot down by the Supreme Court against the United States, and this case specifically created three prongs to which would limit the Commerce Clause. The first prong would be that the government can restrict it if it's a channel of interstate commerce. The second would be the instrumentalities or the necessities of whether or not it's directly involved with interstate commerce, or if anything had a substantial effect on interstate commerce. The way they used this in the cases that we talked about was whether or not, the hypothetical of whether or not you have to be vaccinated was, well, if we allow you to not get vaccinated, then we have to let everyone else choose to whether or not they want to get vaccinated. And in the case that we're discussing a guy who's your typical textbook definition hermit. Like, he doesn't go out, he gets everything delivered to him, he grows his own food, he uses the stream behind his house to shower, so it's not like getting water, he's not paying the water bill, he's not doing anything of the sorts that would allow him to come into contact with anybody else but himself, which the whole point of getting a vaccine is to save other people who are more susceptible, or yourself, and he felt that he doesn't need it because there's no reason why. He's not seeing anyone, he lives alone, he lives in the woods kind of thing, and this issue brought to us would be like, well, if you are doing this and we accept it, what happens if your neighbor chooses to do the same thing? Your neighbor chooses to grow their own food, to use the stream behind both your houses to shower, to do all of this, then we have to accept that. And then the next person, and then the next person, and the next person. And then at that point, most of us aren't being vaccinated. Most of us aren't even engaging in commerce at that point because we put restrictions to, you can't go out if you are not vaccinated, or you can't not wear masks, which would prohibit you from going outside. And we can't do that because if everyone decided to not grow, or decided to grow their own food and not go grocery shopping or not order anything off of Amazon because you have to come in contact with the delivery driver, anything like that, it would cause a major impact. So maybe not one, but for everyone, if we have to accept everyone doing this, then that's where the substantial impact comes in, and that's the argument that we try to make. So the way this applies to today, and the way we would argue it for Mr. Denolf, who's the textbook definition of a hermit, that's the way I like to describe him, is we went into a lockdown a year ago, and we noticed that businesses that weren't essential, which we'll define essential later, had to shut down. A number of them were able to survive. There's people who don't have jobs, kind of thing like that, and if you don't have jobs, you don't have money bringing in, you can't spend money that you don't have. That way, that creates a substantial effect on commerce. We are a very commercial generation. If you order from Amazon, 9 times out of 10, you're not getting something that is made down the street or in your state at all. You're going to get stuff that's made out of the country or out of your state across the country. And like if you order your iPhone from online, that comes from California, stuff like that. That way, the Commerce Clause regulates that because you're engaging in interstate commerce. And one thing that when we were discussing about what we were going to talk about today, Ben brought up a really good thing where it was like people who get the vaccine or get the virus and can't come back from that, people who are very sick, it takes them out of the commercial chain. They're not buying anything, they're not selling anything, they're not doing anything like that, which in turn would go out of the market. And in Whitford and Stillborn, it discusses like growing their own food and like how that affects people, and Denolf, who's growing his own food, that takes them out of the market, which gets the Commerce Clause involved because then that is a substantial effect on the economy. And that's where we were going with that, and that's where we were going to take it in November, which is left.
Thank you, Miranda. And next to Daniel.
So the second issue, to get right into it, is the right to liberty and privacy under the Due Process Clause of the Fifth Amendment, and whether or not Jacobson v. Massachusetts should be revisited. Just to give a little bit of background on Jacobson v. Massachusetts, essentially Massachusetts in 1902, I believe, allowed localities to determine whether or not they needed to mandate the smallpox vaccine. And this was challenged, and the court established that personal rights and liberties are not absolute, and that the state has an interest, a public health interest, in mandating vaccines, and that those public health interests outweigh personal interests that may be violated. And so if you were arguing against vaccine mandates, as a petitioner in our hypothetical would, the first thing you would go to is Buck v. Bell, which using this precedent established by Jacobson allowed for the forced sterilization of individuals deemed unfit to have children by the state. And so you'd harp on this and argue that this is a dangerous precedent set, it's outdated, and so the case needs to be revisited and reversed. Also, you could get into Washington v. Harper, which stated that the forcible injection of medication in non-consenting persons' bodies represents a substantial interference with personal liberty. And so again, a vaccine mandate, there are people that don't want to get a vaccine, people that feel they should not have to get a vaccine. According to that case, something like that would be an extreme infringement on a person's personal autonomy. Cruzen v. Director of Missouri's Department of Public Health allowed for competent individuals to refuse medical treatment. And this also basically establishes that people have a right to accept or to refuse medical treatment. And then there's other cases that don't necessarily have anything to do with public health, but the principles also reinforce this idea of personal autonomy and liberty. Lawrence v. Texas discussed whether or not consensual sex in a home is protected by the Due Process Clause. It found that it was, and the government does not have a right to infringe on what people do in the privacy of their home. The liberty and right to marry are protected by the Due Process Clause, and that extends to interracial couples and same-sex couples. And so again, there's this idea that personal autonomy should not be infringed upon by the state. And so these are sort of the arguments that people that are opposed to vaccine mandates and people that are sort of focused on that idea of personal liberty would rely upon. To counter those, the state, the government would argue that state interests in preserving life and public health outweigh the interests of an individual. And they'd either try to distinguish vaccine mandates from Buck v. Bell or try to justify Buck v. Bell's decision, which, to reiterate, it did allow for forced sterilization of individuals. And so for today, I'll try to distinguish the two, and I feel like that's the more plausible argument. And so you could argue that at the time it was passed, it was in 1927, it may have seemed like it was necessary for public health and safety, but this is 2021. It's pretty clear to us now that forced sterilization has more detriments to public health and safety than benefits. There are other avenues to take care of individuals that may not seem fit to bear children, I guess. And so that's one way of distinguishing it. Just because one case abuses a principle doesn't mean the underlying principle is unjust, essentially. And so Washington v. Glucksberg, for example, held that assisted suicide was not a right because the state has an interest in protecting the poor, the depressed, the disabled, and that allowing assisted suicide could be abused and negatively affect those groups. Youngberg v. Romero, a quote from there states, whether respondents' constitutional rights have been violated must be determined by balancing his liberty interests against the relevant state interests. And so again, you do have a right to various liberties, but those have to be balanced against the state's interest in protecting health of individuals and the society as a whole. And a final case is Union Pacific Railroad v. Botsford. It states that people have personal autonomy free from restraint unless by clear and unquestionable authority of law. And so that's, again, to reiterate the point. And so to bring that back to our hypothetical and to COVID, does the government have an interest in vaccine mandates? Miranda sort of touched upon this, but when people die, that that has a clear negative impact on society as a whole. And so the state has a clear interest in preserving the lives of individuals in a society, whether for commercial reasons or just general public health. Thank you.
I'm so impressed. 3 weeks into the semester, look at all of the knowledge that they've already gathered together and started to synthesize and put together. Let me just add 1 minute of additional commentary on that. The interesting thing, Jacobson, that referred to the Massachusetts case that said that yes, you can require a vaccine for public health purposes, would seem to settle that issue, and then that should be the end of it. But that was 120 years ago, and the concept of liberty, the concept of due process, has evolved a lot since then, as has been described to you in many different circumstances. And so things today that the Supreme Court has found are protected as liberties that we're all entitled to: interracial marriage, same-sex marriage, homosexual relationships. In 1903, none of those things would have been acceptable. The world has obviously changed a lot during that period of time, and the concept of liberty has changed a lot. Now, has it changed enough to the point where we can say we have the right to refuse medical treatment which endangers other people? I don't know the answer to that. That's something that ultimately will have to be determined through the courts, but that's the broader issue that we're going to look at. So great job by the two of you. Super. And now, let's bring up Zach Miner, who will talk to us about essential services and guns.
Thank you very much. Appreciate it. Almost like it's supposed to work that way. All right, great. Talking today about this issue of whether firearms are essential or not, but I actually want to address one issue first that is oftentimes a little bit more confusing to people. While I was doing research for this, I was watching videos on YouTube. They were related to this. And one of the things that came up was the NRA put out a video featuring a woman who was disabled, and she was talking about how she needed to have a firearm during COVID, especially because that would be her only way of protecting herself. And this comment was on there. And so, amen, sister, every gun control law that has ever passed is unconstitutional. This is, believe it or not a uncommon belief among people, and it's due to a misreading, I think, or just a misunderstanding of how interpretation of the Constitution works. So, take the First Amendment, for instance. People oftentimes see the phrase "Congress shall make no law" and say, okay, I know what words mean. Congress shall make no law means Congress shall make no law. It doesn't really mean that, right? We have laws, all types of laws that apply to all of these things that are up here. When places can be open, when they can't be open, who can be the press, who cannot be the press, when can you assemble, under what circumstances can you assemble, all that other kind of stuff. So it doesn't mean no law. It means no law that prohibits free exercise, all that kind of stuff, and that's as interpreted by the courts. I'm so glad that Miranda brought up all these issues about how we've interpreted statements in certain cases, because that's really what we mean. So when we come to the Second Amendment, I had a whole thing all set up. I was going to talk about prefatory clauses and operative clauses, and I'm just going to leave that stuff to the side. The thing that people are interested in here is the shall not be infringed, right? That doesn't mean, we'll never pass any law. It doesn't mean we can't restrict those things. We cannot infringe means we cannot illegally, we cannot unconstitutionally take away people's rights to these types of things. Infringement doesn't mean that gun stores have to be open 24/7, that they can be sold to anyone. There's been restrictions on gun ownership ever since we've been a nation, but since before we were a nation. And frankly, a lot of the early gun ownership laws were all about who could and could not purchase them, specifically limiting purchases only to white men, essentially. To a certain extent, gun ownership restrictions are as American as America is. It's true even before we had in America. So, that being the case, move on to a specific case of disasters and firearms. Probably the most well-known example of this came during Hurricane Katrina, and there's a lot of debate about what actually happened here, but the point of it was that there was claims being made that the city of New Orleans had confiscated firearms from people during the hurricane as it was happening. There were a number of controversial things there, where they were enforcing people to evacuate the city. The city claims that the only time they took firearms was from empty houses. They would go into a house if there was nobody there. If they saw a firearm, they would take it with them and confiscate it. Other people, reporters have stated that they did see law enforcement officers taking firearms from people as they were boarding buses to go to protective centers. So there's a big debate about this. NRA ends up filing suit against the city of New Orleans. Everybody kind of ends up agreeing that it probably wasn't as big a deal. There have been even some pro-NRA voices who've kind of said, you know, guys, this isn't really what we thought it was. So this isn't as big a deal. Yes, it did happen, but it was not part of a plan. Like, it wasn't part of a, we're going to confiscate people's firearms type of thing. And believe it or not, even in subsequent examples, like in the case of Hurricane Sandy, which obviously mostly affected states like New York and Connecticut and New Jersey, which have relatively restrictive gun laws, we don't see that type of thing happening. And even though that's the case, we do actually see a federal law being passed, and people probably can't read this, but essentially it's saying that this is a federal law that was passed since then, saying that you cannot confiscate people's firearms in case of things like evacuations. So you can't seize them temporarily, you can't seize them permanently, it's just not allowed. But that's not really what people were worried as much about during COVID, right? In Katrina, people are worried about, their firearms. We're not so much worried about looting, I suppose, as we were during Katrina. We're more worried about, are we able to access new firearms? Can I purchase a firearm if I want one? If I'm scared, can I go to the gun store and purchase one? So a lot of states kind of had this situation happen where David and I were just talking about this before. It's kind of snuck up on a lot of people. I mean, as you might have been able to tell from the response to it. It snuck up on states just the same as it snuck up on individuals. And so a lot of states were kind of responding ad hoc and making some decisions on the fly. And one of the decisions they tended to make was to close non-essential businesses. And a lot of places didn't have a plan. They didn't have a pre-existing list. And so what they said was, well, we're just going to close any business that isn't, and list whatever businesses you want. So grocery stores, pharmacies, medical facilities, hospitals, all this other kind of stuff. And oftentimes what that ended in was that gun stores weren't on that list, maybe because someone excluded them, but maybe because people just didn't think of them, didn't think they were essential. And a number of different things that happened as a result of that. So there were several states, New Jersey, Maine, and Vermont, that had them, that were in that situation, did not have them listed as protected stores. And then basically the federal government issues an edict, which we'll see in a second. It's a non-binding advisory statement saying that gun stores are essential. And a lot of states use that as their reasoning or potentially as their cover to say, well, the federal government says they're essential, so now we say they're essential as well. So these three states changed their laws as a result of that. Another perspective is what happened in New Mexico and Michigan were that they were sued. They didn't immediately make the change. They didn't immediately change over to saying that firearms stores are essential businesses. They were sued, but then they changed the policies, and then the suits are withdrawn, right? So no actual case law gets made as a result of this. They just say it's done at this point. So really only 3 states had lawsuits that reached any kind of a conclusion. We'll talk about each of these, and we'll save ourselves for the last because we're actually probably the most meaningful in this particular case. So in New York, what happens is their lawsuit ends up being dismissed due to something called lack of standing, which means that you have to be a person who is actually harmed by the conduct that takes place. And it was the NRA that was suing. And the essential message that the court passes on to the NRA is saying that, this didn't have any effect on your day-to-day operations, right? What they said was, well, we had to redirect some of our people who would have been doing other things. They would have been training people in firearms. They would have been doing other things. Instead, we were fielding calls from people and trying to help them figure out where they can buy a gun. And the judge didn't buy that, basically said, look, that's what you do anyway, right? You spend a lot of time talking on the phone to people and giving them information. This really isn't different from your day-to-day business. And so the statement is they couldn't show that they had burdened the plaintiff's ability to carry out his usual activities. So they said, you don't have standing to sue. Basically, by the time that happened, by the time that got to the court, by the time they realized they needed to find somebody who had standing, the laws had already been changed, right? What this does in the end, essentially, it does establish this idea that for a lawsuit to be successful, somebody who's actually affected by it has to be the one that files it. So that's not the case everywhere. It's not the case that the NRA sued absolutely everywhere. If you look at the case in California, for instance, there were gun stores that were filing these lawsuits, and they could plausibly make a case that they had been damaged by their business being forced to close, essentially. What ended up happening was the judge denied the temporary restraining order that the gun stores were seeking, saying that we need to be allowed to reopen. And what essentially the judge said was, and this is probably the most useful part of this for the discussion here, is that we need to use a standard called moderate scrutiny moving forward from here. This is where it gets really boring. It's the difference between moderate scrutiny and strict scrutiny. It's really boring. It's extremely important, though. What moderate scrutiny means is when a law is passed, you have to be able to meet two things. You have to say whether the government's stated objective is significant, substantial, or important. So in this case, public health, yes, those things are substantial and important. And whether there's a reasonable fit between the challenge regulation and the asserted objective. Does the thing that you're doing reasonably have something to do with what's actually taking place? To read directly from the case law here, they say this disease spreads where an infected person coughs, sneezes, or otherwise expels aerolized droplets containing the virus. So the closure of non-essential businesses, including firearms dealers and ammunition dealers, reasonably fits the city and county stated objectives of reducing the spread of the disease. So by using this standard, they say, yeah, this moderate level standard, they passed a law that was related to this and related to a substantial government objective, which is public health. So it's okay. So we will not grant your request to stay open. Now, in the end, again, California ends up changing its laws. The pandemic gets a little bit less bad. Stores reopen. It's not really that much of a big deal. Now, Massachusetts. Ooh, we're a little bit different. So, March 23rd, Baker issues the order saying which businesses are essential, which ones aren't. Gun stores are not on that list. 28th of March last year, that's when DHS issues its non-binding guidance, basically saying that gun stores are essential and should be allowed to stay open. That's when a lot of states sort of make their turn and say we're going to move on. Then March 31st, Governor Baker issues a new order that initially says gun stores are essential, and then later in the day just changes it and says that they aren't anymore. That's sort of the most confusing part of all of this. So then, a group of Massachusetts gun stores file suit. Again, they are people who are potentially harmed by this. And in the end, on May 7th, a district court issues a preliminary injunction allowing sales to continue, provided that they follow COVID protocols, including social distancing, all that kind of stuff. Now, the reason that happened is because of the First Circuit Court of Appeals. I told you it was going to get boring. So Massachusetts is up here. We're in the First Circuit Court of Appeals. California's over here in the Ninth Circuit. The circuit courts are very different from one another. We don't actually super have to get into why. But in the First Circuit Court of Appeals, there was a case called Gould v. Morgan that establishes a two-step analysis for Second Amendment cases. You have to meet two standards here. First, the court has to decide whether the challenged law actually burdens conduct that has to do with the Second Amendment. And then they get to decide what level of scrutiny they want to apply to that. So in this case, the judge says, we're not going to use intermediate scrutiny. We are going to use strict scrutiny. So the other judge said we were going to use the lesser standard. This one says we're going to use the more stringent standard. That means that, yes, the restriction involves a compelling government interest. But in this case, it has to be narrowly tailored to achieve that interest. In this case, the judge doesn't buy it. The judge says, by closing a few gun stores, are you really stopping a pandemic? Is that really substantially reducing the amount of transmission, especially if the stores have offered to follow all COVID protocols? So, doesn't buy it and basically says they have to reopen. And so they do. And so we have these conflicting rulings at the district court level, right? So these don't affect each other because they're in different parts of the country. We don't have the Supreme Court deciding yet. And that's what remains to be resolved, right? Which is, number one question, which level of scrutiny are we actually supposed to use here? Because different courts have found different things. The question also becomes, if you allow any kind of sales, is that okay? You know, we can, in Michigan, for example, they allow curbside sales. You order online, come and pick up in person. Is that enough? Is that enough sales? Is that okay? Is it only if it's a full ban do we have to shut it off, basically? And also, it sounds like a dumb question, but what is a gun store? What is a gun store? Is Walmart a gun store because they sell guns? Maybe not so much anymore, but any of those like Cabela's or something like that, they also sell food. They also sell outdoor gear. Are they a gun store or are they not? Is a gun store that also sells toilet paper an essential business? It seems like a foolish question, but foolish questions produce the best answers. So I will leave that there for now, and I will make way for other people.
Fascinating presentation. It's interesting, the Supreme Court actually does have a gun rights case on its docket for this coming term that they'll hear sometime this fall, and maybe we'll get some more answers to those questions, but very, very well laid out. And now again, to shift from the legal to the ethical, Dr. David Svolba.
Okay. Okay, I think I'm at the I see. Yes, that's mine. That looks familiar. We good? Okay, great. Thank you. Well, it's good to kind of see everybody. Anyway. So as Paul said, I'm going to be addressing the question whether we have an ethical obligation to get vaccinated. And as a philosophy professor here at FSU, philosophers are much more comfortable raising questions than answering them, so I won't be defending a particular answer to this question of whether we have an ethical obligation to get vaccinated. Rather, what I intend to do is just give you a sense of those who do give answers to this question, what are the most prominent arguments they give for or against, right? That's what I'll be doing. But the first thing I want to do is say something about ethical obligations. What does it mean to ask whether we have an ethical obligation? And the first point I'd like to make is that questions about ethical obligation are importantly distinct from questions about legal obligation, okay? So there's this fascinating question, which the other panelists have already addressed, whether governments, whether at the state or federal level, would be in some sense overstepping their authority by using their considerable coercive powers to get more people to vaccinate. And so questions about whether we should support vaccine mandates, or perhaps even more stringent laws such as compulsory vaccination, like you see in some European countries where failing to get vaccinated can go along with jailing or very significant fines. These are not the questions I'm interested in for the purposes of this talk. And the reason is as follows. Suppose you think that we do have an ethical obligation to get vaccinated. You might nevertheless think that it is not a legally enforceable one, right? You might think that, yes, we're ethically obligated to get vaccinated, but the government shouldn't be in the business of penalizing or punishing those who don't do it, right? So you probably already have such beliefs with respect to things like, I don't know, let's say adultery, right? You might plausibly think that there's something ethically wrong about adultery. You might think we have an ethical obligation not to cheat, as it were, on our partners, but you might think it would be a very bad idea if the government were to institute like monogamy mandates, or were to apply some sort of penalties or punishments to those who were unfaithful. So what we would say here is that thinking that something is an ethical obligation is not sufficient for thinking that it is thereby or thereby should be a legal obligation. Interestingly, nor is it a necessary condition, right? So now imagine somebody who thinks we don't have an ethical obligation to get vaccinated. That person might nonetheless think we should have vaccine mandates, right? They might think, although no particular individual is ethically obligated to get vaccinated, it is such a compelling public good, and the coercive power of the law is clearly the most effective kind of instrument we have for getting widespread vaccination, so we ought to apply mandates in the interest of public health. So the fact that you can support mandates while thinking there's no ethical obligation, and the fact that you can affirm an ethical obligation while not supporting mandates suggests here that we have two rather distinct questions. All So, what on earth am I talking about? Right? It's clear I'm not talking about the legal/constitutional questions. What then are we asking about when we ask about ethical obligations? That's a big question, the nature of ethical obligation, but I can give some sketchy remarks. Okay, so first, to say that we have an ethical obligation to do something suggests that others can reasonably demand of us that we do it, right? And they can expect us to do it. And that we would be kind of on the hook if we don't do it. We would have to provide others with reasonable excuse as to why we did not do it. It's to suggest that by failing to do these things, we would be appropriately subject to what the great English philosopher John Stuart Mill called the social sanctions, right? Which he opposed specifically to state and criminal sanctions. And the social sanctions are going to be things like blame, moral indignation, condemnation, scorn, ostracization, so on and so forth. So when we're asking whether we have an ethical obligation to get vaccinated, think of it this way. We're asking whether other people can legitimately demand of us that we be vaccinated, and we're asking whether those who refuse to get vaccinated, let's say for non-safety reasons, right? Those who refuse to get vaccinated, although they safely could, are they in fact appropriate targets for the social sanctions? That's our question. Okay. So what I'm going to do now is I'm going to kind of quickly walk you through the two most prominent arguments for the claim that we do have an ethical obligation to get vaccinated, as I've just characterized the nature of ethical obligation. There are many arguments, but these two strike me as the most prominent. So the first we can call the prevention of harm argument, and that argument goes a little something like this, right? You start with the claim that, and it's a plausible sounding claim, if you can prevent serious harm to others, or if you can significantly reduce the risk of serious harm to others at little cost to yourself, then you're ethically obligated to do so. And then the second claim is that, well, by getting vaccinated, you can prevent serious harm to others, or significantly reduce the risk of serious harm to others. And so the conclusion seems to readily follow, you ought therefore to get vaccinated, right? That's the argument. This is an argument you will see everywhere among those who defend this idea that vaccine refusal is ethically wrong. Now, is the argument universally accepted? Of course not, right? This is ethical philosophy, so none of this is universally accepted. There is pushback. What is the nature of the pushback? Well, there are concerns about vaccine safety, right? So it's an undeniable fact that some people have had adverse reactions when taking the major COVID-19 vaccines on the market right now. And the idea is that insofar as there is the possibility of adverse reactions, to what extent can we confidently say that people would be getting these vaccines at little cost to themselves? They might be assuming a risk that in their minds is not of little cost. Now you might think, oh yeah, but the chances are so rare that they would have an adverse reaction. And I might agree with you, but there's also this general principle that it's not up to us to do the cost-benefit analysis for others, right? It's up to them to analyze whether the benefits outweigh the risk when it comes to their own personal health. So that's one area of pushback. There's also those who claim, look, what makes the vaccine situation different is that there's the possibility of self-protection. I am not the only one who can reduce the risk of you being seriously harmed. You can too. Go get vaccinated, right? That's the response. Don't ask me or demand that I get vaccinated. If you're so concerned about minimizing your risk, why don't you go get vaccinated? Now, of course, you might say, but there are some among us who cannot get vaccinated, right? There's the immunocompromised. There are children under the age of 12, at least right now, who can't get vaccinated. And so then the response is something along the lines of, well, vaccinating the unvaccinated is not the only means of reducing risk of harm to these members of the population. There's also just a matter of one could elect to stay away from them, one could use masks, one could do things other than vaccinate in order to minimize the possibility of harming those other members of the population who are not themselves vaccinated for reasons of safety. So that's the prevention of harm argument and the typical kind of pushback you get from those who don't buy it. The second major argument in support of the idea that we have an ethical obligation to get vaccinated, I'm going to call the fairness or no free riders argument. And this is subtly different from the first one. This one starts from the idea that herd immunity, right, which is a concept we're probably all familiar with at this point, or even something less than herd immunity, but high immunization rates in a population is something from which we all benefit, right? And the idea is that since we all benefit from it, it is only fair that each individual member of that population or community contribute their fair share to securing and maintaining that really important public good, right? And the idea is that those who benefit from the public good, yet refuse to contribute their fair share, are in effect free riders. They enjoy the benefits of the public good without having shouldered their fair share of the costs. We tend to think free riding is wrong, it's unethical, and so the argument goes insofar as vaccine refusal, let's say for reasons not having to do with not being able to safely take the vaccine, any other kind of vaccine refusal is tantamount to free riding and therefore ethically wrong. These, again, are the two major arguments. There are many others, but these are the two most prominent. One based on fairness and no free riding, the other based on the prevention of harm. Okay, so that brings me to the major argument in support of the idea that no, we do not have an ethical obligation to be vaccinated. And here, as has already been mentioned by some of my other panelists, by far, the argument you're most likely to encounter is something we can call the bodily rights argument or the bodily autonomy argument. The idea here is that our rights to control over our bodies, our rights to bodily integrity is really one of the key individual rights in all of the important human rights documents, right? So in the Universal Declaration of Human Rights, you find it there. In the European Convention on Human Rights, it has a prominent place. So the idea is that we have these rights to control over our bodies, and presumably the right to control my body is going to entail a right to control what goes into it. Right? It would be strange to suggest I have a right to control the use of my body, but that I do not have the right to say what will and will not go into it. Now, interestingly, you might say, well, we already tell people in a society like ours what can go into their bodies. Right? We say, for example, that heroin cannot go into your body. But I think it's important to acknowledge that those laws, too, are controversial. So the people who are arguing about this and about whether the bodily rights argument is a successful rejoinder to those who say they have an ethical obligation to get vaccinated might also be the people who think our current drug laws are ethically baseless as well. But they might also say this. They might say, look, it's one thing to tell me what I cannot put into my body. It's another thing to tell me that there's some substance I have to put into my body. Okay? And so this is the bodily rights argument. That if we take this kind of right to bodily integrity seriously, we have to acknowledge that we can't reasonably demand of others that they put things in their bodies that they don't want to put in there. We can't reasonably demand of others, as I think Paul mentioned earlier in one of the panelists, that they undergo medical procedures that they do not want to undergo. It's a bedrock principle of medical ethics, after all, that you cannot perform medical procedures on anybody without their full voluntary consent, right? And a vaccination is a kind of medical procedure. So this is the bodily rights argument, and this is the final point I make. There's pushback here as well, of course, pushback that I think kind of dovetails nicely with some of what the other panelists have been talking about, and that is that individual rights are not absolute; they're not inviolable. We recognize and have recognized and continue to recognize that there may be such compelling considerations of public health / common good that we're willing to infringe on individual rights in very special circumstances. Jacobson v. Massachusetts is an instance of that, I think. Part of the explicit rationale for the decision was that there comes a time when if the exercise of individual liberty imperils the common good, then we have to side with the common good or something to that effect. Now, of course, there are also questions, as Paul mentioned, as to whether Jacobson v. Massachusetts it still applies in spirit, right? It still applies in letter, obviously, but if it still applies in spirit to how we think about these issues today. But that's some of the pushback to the bodily rights. Yeah, so those are the major arguments for and against, different answers to the questions that we have. Thank you.
It's one of the great ironies of this, of course, the my body, my choice signs are usually more associated with abortion. And many of the people who are using that as their mantra now would be opposed to abortion.
Yeah.
And so there's some inconsistency there, which is interesting in the both legal and ethical. Well, thank you for that. That's wonderful. We do have a little bit of time for a question and answer, right? And so I know we can take questions in person. I assume they can chat them on Google, and we'll read them if necessary. Yes. So either way, if you're viewing this on Google and you have questions, shout them out. If you want to raise your hand here, we have microphones, and we'll get them to you. Or if any of the panelists want to ask something that you want, you're welcome to do it too. Anything you have that you want more information on? While you're thinking, David, maybe you could talk about that abortion conundrum, how that fits into your thoughts, because I'm curious.
Oh, gosh. Yeah, well, I mean, the first thing I'd say is there are a lot of people who kind of sit with this tension, where they're vehemently opposed to abortion on a moral level, yet they, as you said, appeal to this idea of my body, my choice when it comes to vaccinations. But there also are people, quite interesting, who are finding themselves now politically aligned with people they never thought they'd be politically aligned with, because, you know, they're willing to accept the kind of logical implication of that principle. And so they're willing to accept that just as they claim a right to kind of control the use of their bodies with respect to gestation, say, others should have the right to control the use of their bodies with respect to vaccination. So there are people on each side, I would like to think, who kind of bite the bullet and accept the logical implication of their beliefs. I agree with you that it does seem to be the logical implication of a my body, my choice position. I can't readily tell you or give you a nuanced way of distinguishing between the two such that you can consistent. I mean, I suppose one thing one person would say is that, well, rights are not inviolable, right? And so in the abortion case, the interest in protecting the life of the unborn child is so compelling that the bodily right is overridden. Whereas in the vaccination case, the interest is not correspondingly compelling enough to override the bodily right. So in each case, you have an appeal to this incredibly important individual right to bodily autonomy, but in the abortion case, I take it, anti-abortionists would say the interest in protecting the child's life is just too compelling to override.
I can't speak philosophically, but from a political perspective, you see this all the time.
Yeah.
Trump deeply held beliefs Trump ideology all the time. It doesn't have to be consistent. Yes, Sarah.
Well, just related to that, the idea that one's protecting the unborn child, and yet one is not necessarily willing to protect the born child who's below the age of 12.
Right, yeah. And again, I don't, please don't take me to be different.
No.
But I suppose what they might say is that the causative link between an abortion and harm to the fetus is much, much clearer than the causative link between not getting vaccinated and some sort of subsequent harm to some member of the population contracting COVID-19.
Okay, so I have a question, a contextual observation is what I'll make first. And I'm wondering how this conversation would be proceeding at another state institution in, say, like Georgia, where, you know, here in Massachusetts, in a state institution, we are sort of considering the coercive state and the power of the state and kind of having a conversation within, you know, what are the limits that we're going to put on this state that's taking these actions? Whereas at Georgia, where I have friends who teach at the University of Georgia who have been pushing strongly because the state seems to have abdicated its responsibilities. And so how do the arguments shift when you are arguing against a coercive state versus trying to encourage a state to enact its responsibilities? The gun issue arises too, because I think about somebody like Condoleezza Rice when she was a child in Birmingham. She said, "I'm always a defender of the Second Amendment because I was under attack from my own state. Black people were under attack from, literally the powers of the state, and so we have to take the right to defend ourselves." And so you see these sort of, depending on your perspective within those moments, the arguments change. I'm wondering what
So just to summarize for those on Google, the question is how do regional and environmental factors change or affect the outcome of these questions?
Well, I mean, my initial thought is that I'm skeptical to what extent ethical arguments like the ones I sketched very, very briefly without any nuance here today. But those ethical arguments, I'm very skeptical to what extent they determine any legislation for political decisions. I think if we look at kind of regional ideological differences in this country, that's what's driving the different responses to these various crises. That's why a university in Georgia is deciding not to do things that a university in Massachusetts is quite comfortable doing. It's not because they've weighed the arguments and come to different conclusions, or that they've kind of encountered different arguments. It's that the people making the most important decisions, I think, are beholden to very different voting populations that have their own.
Somehow vaccines have become a political issue, not a scientific issue or a philosophical issue anymore, and it splits along these remarkably ideological lines. We're a very polarized country.
But there are some of us, and hopefully a lot of us at universities like this one, who want to know what the arguments are, right? Like we have this idea we'd like to aspire to hold the reflectively most defensible positions. So,
Another question in the back.
Zach,
Oh, I'm sorry. I was going to respond.
Zach, could you turn on your mic?
Oh, yes, I can. I was going to respond to Kate's point by saying that, and maybe this is relevant to what David was saying, that I think it's the rare person who has a very specific reason that they always follow a particular perspective. I think many people are more comfortable than they realize holding contradictory positions, and one becomes very uncomfortable when that's pointed out. And I think people who are in academia maybe have resolved some of that by coming around and saying, okay, I guess I just have to follow logical arguments more often than not, although we're still happy to have some contradictory beliefs as well. But I think most people just don't think about it, right? You could point out the connection between abortion and vaccination. I think people can still hold the same perspectives. So with firearms, I mean, I think if somebody comes from a perspective where they say, I support this because I had this experience in my own life, at least that's a standard that they're using. And they say, I will use this standard to judge all things in the future. I don't know that that would necessarily be guiding for everything, right? I'm not sure that a person who felt like they were under attack from their own state would say everybody should have a firearm in all circumstances, right? So, my point, I guess, is that people are very happy to hold contradictory viewpoints and probably don't even realize that they do.
Thank you for that. Yes, in fact.
What do you think is the consideration for the precedent that currently, if you want to attend a public school in the state of Massachusetts, you have to provide vaccination and shot records in order for your children to enter the school system?
Yeah, excellent question.
Using this as a jump point to add the COVID-19 vaccination in that list of vaccinations required for school.
Yeah, excellent question again. For those on Google, the question was, we already have a precedent that we require vaccines to attend public schools for polio and measles and mumps and everything else all under the sun. Well, is that a precedent to add the COVID vaccine onto that? Any panelists want to take that one? Or do you want me to do it?
I don't think I need this, but I'll put it on there. So
You do for
glad-
Google.
I'm so glad I did that. Okay, for Google. It's for you, Google. I'm always doing everything. Yes, so, I mean, I suspect that the response on the part of those who are generally opposed to the idea of adding the COVID-19 vaccination is that we have nowhere near as much data, or at least this is the claim, as we do, for example, the safety and efficacy of the measles vaccine, or something like that. For obvious reasons, we lack some knowledge of potential long-term health risks associated with the vaccines. We're learning every day and kind of updating, as we should be, our understanding of how effective the vaccines are, in what circumstances they're most effective, et cetera, et cetera. And so I think there are people out there who would say, the difference is, the reason why there's no straightforward inference from, well, we already do this, to add the COVID vaccine, is that the COVID vaccine is in some way relevantly different from these other more well-established vaccines. Whether that's an argument that holds water at the end of the day, I think is another question, but I think that's how we would respond to that particular argument. That, don't we do this already? Right? Let's solve a vote.
Yeah, it's a fascinating question. Obviously, only one of the vaccines at the moment still has full FDA approval. The others are pretty close to it. It was developed in the shortest time frame in history of vaccines and medicine. On the other hand, something like 200 million Americans have already seen the vaccine.
Yeah.
That's an awfully big data set
Yeah.
from which to work. And there's probably no scenario where the FDA is not going to approve these vaccines at this point.
Yeah.
So, interesting question for sure. Again, I think it always come up. We had a question from Google.
Absolutely. So the question is it correct to state that ethical behavior supports the common good? There is, of course, a question of how we determine common good, and then empirical evidence, question mark.
Common good.
Wow, interesting. Well, I mean, here's one very simple way of understanding the common good, okay? It's well known that vaccines are doubly beneficial. They are beneficial to the person who takes the vaccine, and they're beneficial indirectly to the people with whom that person has interactions, right? I think there is a straightforward distinction to be drawn between the benefits that accrue to the individual agent and the benefits that accrue to others outside of the individual agent. What we call the common good is just those other than the individual agent. We're opposing the common good to the good of the agent or the self-interested good. That's the distinction we're drawing. As for empirical evidence, question mark? I don't know exactly what that means, but it sounds vaguely snarky, so let me say that. So by empirical evidence, question mark, one thing I hope came, I didn't emphasize this when I quickly rattled off the arguments, but empirical evidence is crucial here, right? So in the prevention of harm argument, the success or failure of that argument, how compelling it ultimately is going to depend largely on what we come to know about the extent to which vaccines actually prevent harm or significantly reduce the risk of transmission, so on and so forth. Those are all empirical questions, right? So ethical arguments are always beholden to empirical evidence, right? It's just you can put the argument in such a way where you say, look, we don't yet know where the chips are going to fall in terms of empirical evidence, but if this, then that, right? And that's where we are with a lot of the ethical arguments.
Should we wanted you to know that it was not smart.
We have time for one or two more questions. Yes, please. Joe.
How does the approval of, or the FDA approval of vaccines affect the legality of a vaccine mandate?
That's a good question. If no one wants to do that, I'll take it. Yeah, I mean, I'm not sure that it does. Honestly, we've never had a scenario where we mandated a vaccine that wasn't FDA approved, but we've also never had a pandemic that killed 600,000 Americans in a year, dealt with the circumstances that we had. So it's all somewhat uncharted territory. I'm not sure it has any legal significance, but it is an argument that people use to justify caution or wanting to wait. As I said prior, with 200 million people already being vaccinated, there's simply no scenario where the FDA is going to say, well, you know what, maybe we shouldn't have approved this, and so we're going to It's inconceivable that can occur. So I can't imagine from a legal standpoint it's going to have much weight, but there are challenges going on constantly. Last week, President Biden came out with some new, tougher federal mandates. Several states have already rushed to the courthouse for the opportunity to grandstand against that and bring the first lawsuits. We'll see, but I'm sure that's going to be a piece of where they Other questions? I want to leave you with one more precedent, something to think about as well, which hopefully relates back to you too. Some students at the University of Indiana brought a challenge to that university's vaccine requirement. And it went to the 7th Circuit Court of Appeals, who considered the case and ultimately ruled in favor of the University of Indiana. And in doing so, they pointed out that when you sign up to be a college student, that there are going to be some things you have to do that you might not otherwise want to do. There might be books you're required to read that you otherwise wouldn't pick up. There might be papers you have to write that you prefer not to think about. And so I just like this quote. It's now all my syllabi. But the 7th Circuit Court of Appeals has ruled that a student must read what a professor is saying. So I just want you to take that away today. There's the citation. It's not me saying that. This comes with the force of law. So I figure that's yes. When you're registered, you sign up for the whole deal, and it includes that. And again, I quote: "A student must read what the professor is saying." So if you remember nothing else from today, hopefully it will be that. Yes.
We're in the first circuit. I would know.
Yes. It's a fair point, and I respect that. It's not necessarily binding law here in Massachusetts, but it is persuasive, and therefore I would suggest that I would suggest barring further legal action. That should be followed.
If I could just say one last thing. Also, when I was asking about whether we have an ethical obligation to be vaccinated, I don't know if I said this, but I was thinking of we as members of the general public. There are other, importantly different nuances and complexities involved in asking whether more specific populations have an ethical obligation to be vaccinated that other populations might not, right? So you might think that the general public, the case to be made for the general public having an obligation is, it's a harder case to make than making that same case for healthcare professionals, those who work in nursing homes, so on and so forth. So that's something to keep also.
Well, thank you all for coming out today and helping us celebrate Constitution Day 2021. Keep an eye out for more great general education ideas and events throughout the course of the semester. And good luck with your studies. Thanks, everybody.